We would like to thank the Indiana Criminal Justice Institute for providing the funding for this video. We hope that the information provided will assist those who've been victimized or are struggling with a legal issue. Today, we'll be talking about guardianship of children. Let us start with a story. 5 years ago, Lisa's daughter Annie gave birth to a beautiful baby girl named Lexi. Sadly, Lexi's father died shortly after Lexi was born. The next few years for Annie were hard. She bounced around from job to job, had financial setbacks, was evicted from her apartment, and began taking drugs to cope with the depression that she was feeling. Lisa helped Annie whenever she could, taking on Lexi on the weekends and often 1 or 2 days during the week. Last month, Annie was admitted to the hospital for her depression, and inpatient treatment has been recommended. Lisa would like to take care of Lexi full-time while her daughter recovers. Annie thinks that's a good decision, but neither of them know what to do. Perhaps you know someone who's been in the same situation. Fortunately, there is hope for Lisa and Annie. In Indiana, we call this solution guardianship of a minor. A guardian of a minor is a person appointed by the court to take care of a child or children when the parents are not able to do so. The court will not appoint a guardian if mom or dad want to and are able to take care of their own children. But sometimes moms and dads need help to work on their own issues before they can give their children a stable home. A guardianship does not mean that mom or dad do not love their child, nor does it mean that mom and dad will have their parental rights terminated. A guardianship does mean that the person appointed as guardian has legal responsibility for the child. The guardian can take the child to the doctor and to school, and the child can be placed in a loving and nurturing and stable environment. In fact, many, if not most guardians, are family members, and many guardianships are done through the agreement of all the parties. How does a guardianship of a minor happen? If you want to be guardian, you must file a petition in court. A petition is a written request asking the court to do something. In this document, you would explain to the court why the guardianship is needed and ask the court to appoint you as the child or children's guardian. A copy of the petition must be given to the parents and to any child who is 14 years old or older. This is called service of process. You must be able to prove in court that each living parent and any children over the age of 14 received a copy of the petition and notice of the hearing. The court then holds a hearing, looks at the facts, and determines what is in the best interest of the child and whether you should be guardian. If the court decides that you will be guardian, you will receive paperwork that the judge has signed. It is important to keep this paperwork in a safe place. A guardianship will end when the child turns 18. It can also end earlier if mom or dad petition the court to terminate the guardianship and the judge decides that they are now able to take care of their child. Asking the court for a guardianship of a child involves a lot of paperwork. Sometimes the paperwork can be confusing. It's always a good idea to have an attorney help with this process. Indianapolis legal aid attorneys are very experienced when it comes to guardianships. If you think you need guardianship of a minor, we may be able to help you. Please schedule an appointment to discuss your situation further.